Good morning. This is Jeff Fraser. We are having this presentation this morning to follow up the presentation that we had yesterday, and we promised that we would go through the questions that we had received yesterday and try to provide answers and guidance. A couple of notes before we get started. There were a number of questions yesterday about whether we would share the PowerPoint slides. We've done that. They're in the chat area. We also have shared the audio from yesterday. That's in the chat area as well. We are audio recording today's questions and the answers, so that will be available later today or early tomorrow. Again, we're going to spend an hour. It's myself, Cathy Tracey, Neil Williams. By the way, we continue to track the issues that are going on. Obviously, we have the new executive order from Governor Whitmer, and I just learned this morning that the Tokyo Olympics have officially been postponed for perhaps up to a year. The mechanics of how we're going to do this morning is that we have divided up all of these questions. We're going to read each question and provide our best answer in order to make sure that we do this from different perspectives. I'm going to take 5, then Cathy will take 5, and then Neil will take 5. Remember, Neil's specialty is the tax aspect of this, so at some point he may have fewer questions to respond to. Just so you all know, because this is in a state of flux, we're going to give you our best answers, our best judgment based on where the law is now, what we understand from all of the data and information we've been gathering. But obviously, there's still no guidance from the Department of Labor. I checked their website before we logged on. And so oftentimes you'll hear us say something like, unless the US DOL changes through guidance, that's probably the best we can do. So with that, I am going to kick off. Again, I'll read the question, I'll provide an answer, I'll do 5, and then we turn it over to Cathy and then Neil. So here's the first question. I have a part-time employee who is not eligible for any benefits at our office. Would it be reasonable to move her to unemployment prior to April 2? So I'll hesitate there, right? You can do anything you want before April 2, but our view is that won't trigger any rights under the emergency FMLA or the emergency paid sick leave if the event occurs before April 2. The next section of that question is the law retroactive to a certain date? The answer is no, it's effective on April 2. The next question, what is considered a very small employer? Not quite sure what the question really means, but remember the acts apply to employers less than 500. There are some specific provisions that relate to less than 25 and less than 50. Next question, how do we handle employees who are self-quarantined because they are simply afraid, no symptoms or medical documentation? Our response to that is it's not FMLA and it's not paid sick leave. We understand that employees have to make life decisions, but particularly if you're an essential service, you have to make some tough decisions too. If you need employees there and they're not covered by any of the acts, you may have to either tell people, look, stay on furlough or layoff, or hey, we really need you back, and if you can't come back, it becomes a disciplinary issue. And I know that sounds awful, but you have to run your business if it's an essential business. Next question, is an employee eligible for leave to take care of self and other individual? Again, under the regular FMLA, somebody can do that. Under the emergency FMLA, it's got to be taking care of a child under 18 years of age because the school or the daycare, childcare is closed. Last question, is the act retroactive? The answer is no. So Cathy, you're up.
All right. The first question is, the questions we need clarification on is, does the employee have to be employed and not in a, quote, laid off, end quote, status to be eligible for federal dollars? Based on our read of the law, an employee could not be laid off due to lack of work, even if it is triggered by all of this stuff going on with COVID-19, and still receive paid time off under the Emergency Paid Sick Leave Act or FMLA extension. This is because if you read the statute, employees are entitled to paid leave to the extent that the employee is unable to work or telework due to a need for leave because of one of the 6 reasons specified in the Emergency Paid Sick Leave Act, or for caregiver leave as specified in the FMLA extension. So, our opinion is if they are otherwise laid off, that simply they wouldn't be unable to work for those reasons. They'd be unable to work because of the business closure. Second question, and I think this is a big one, is if we are mandated to shut down by Governor Whitmer, somebody anticipated this correctly, let's say for 3 weeks, how does that work with this Emergency Paid Sick Leave Act and unemployment? So after taking a close look at the executive order and meeting it as a section last night, we evaluated the terms of quarantine and, quote, isolation. And we looked at how they're used by the CDC and other public health agencies. And our employment section agrees that there's a very good possibility that Governor Whitmer's order from yesterday does not trigger Emergency Paid Sick Leave or Family Medical Leave Extension Act. The reason for this is that her order doesn't seem to meet the definition of a, quote, quarantine or a, quote, isolation. So according to the CDC, a quarantine is defined as the separation of an individual or group reasonably believed to have been exposed to a quarantinable, communicable disease, but who are not yet ill, from others who have not been so exposed to prevent the possible spread of the quarantinable, communicable disease. CDC also more generally explains on their website that a quarantine is something that separates and restricts the movement of people who were exposed to a contagious disease to see if they become sick. Isolation, on the other hand, is something that separates people who are already sick with a contagious disease from people who are not sick. Michigan law doesn't have any statutory or regulatory definition for these terms. On the Michigan Prepares webpage, it just says that a quarantine is used to separate and restrict the movement of people who may have been exposed to a contagious illness, but don't have symptoms to see if they become sick. Those individuals may or may not be contagious. It also says that a quarantine is a person or well-defined group of people who have been exposed to a highly dangerous and highly contagious disease. So, I think we've all read countless Facebook posts and internet articles where people are talking about being in social isolation, but from a legal perspective, the term isolation really applies to people who are already sick. A quarantine more closely applies to what Governor Whitmer has done because she is restricting the movement of people, right? The concern, however, is that she never calls it a quarantine, and her order seems to apply much more broadly than to those who have only been exposed. So, the bottom line here is it's possible that Department of Labor regulations or Governor Whitmer's office could provide clarification on this and say that her shelter in place really is a quarantine or isolation order, but I wouldn't count on it at this time. With respect to the unemployment issue, employees who can't work because of business closures related to this order issued yesterday will be eligible for unemployment. Also, under one of her orders from last week, an employer or employing unit won't be charged for unemployment benefits if their employees become unemployed because of one of her executive orders requiring them to close or limit operations. So your employees should be entitled to unemployment, and you should not be charged for that. Next question. We have an employee that we asked to self-quarantine due to coming back from vacation overseas. Would this be covered under number 2? Number 2 being the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. However, the self-quarantine will be over before the act becomes effective. So the answer is to that is no. If the employer asks an employee to self-quarantine, that would not be covered by the Act. The self-quarantine must be advised by a, quote, healthcare provider. So if it's just an employer asking an employee to self-quarantine out of an abundance of caution, that's not going to be covered by emergency paid sick leave. Next question is, if an employee is an employee covered if they are a grandparent taking care of a grandchild due to school being closed? The answer to that is possibly. So employees can take emergency paid sick leave or FMLA extension if they have a, quote, son or daughter that needs care because of school closing. So if the employee or grandparent stands, quote, in local parentis to her grandchild, and that means that the grandparent has basically taken on day-to-day responsibilities to care for or financially support the child, then that grandparent would be entitled to take this leave to care for their child during a school closing. Next question, if mom or dad work for the same employer, do both parents fall under the protection to care for a child at the same time, or do they both have the same number of days covered? Answer to that, I think, is yes, based on the way the statute is written. For purposes of emergency paid sick leave, both parents would be covered if they need to care for a child. That being said, I think they'd have a tough time establishing that they're both needed to care for the same children at the same time. Arguably, if you had multiple children or special needs children and more than one parent, or someone is really sick, more than one parent might be, quote unquote, needed at the same time. But that might be, I think it would be a hard sell to say that both will be needed to care for children in the normal course. With that, I'll turn it over to Neil.
Thanks, Kathy. I'll use my first turn here to go through, kind of combine a lot of different questions that we've received on the mechanics for getting the cash benefit of the credits and how quickly companies can do that. And I think part of the confusion is just differentiating between withholding and depositing of withholding that employers make. And so what the Act says is that when employers are paying their employees, and this doesn't just apply to someone that's on leave, but this would apply to all of their employees, you would continue to withhold from employee paychecks the same amounts that you typically would. What's different is that after you effect that withholding, you are not required to deposit it with the IRS, and that would cover withholding for typical employment tax like FICA, FUTA, but also withholding on employees' paychecks for federal income tax. And so just to give an example of what that means, say you issue someone a paycheck, you have someone taking qualified leave, and you issue that employee or another employee a $200 paycheck. And the typical withholding on that paycheck, for purposes of the example, say it's $50, and that represents FICA, FUTA, and the employee's federal income tax withholding. You would still withhold that $50. You just would not deposit that $50 with the IRS when you would make your, along your typical payroll deposit schedule. And so by keeping that $50 out of that $200 paycheck, you've now covered, $50 of the total $200 credit that you're going to get for that check. You can do this for all of your employees, so it's not just for the employee that's on leave. So in the example above, if you had one employee on leave, you had 3 other employees that were still working, so you can withhold a total, again, if everyone's getting, in the example we used $200 paycheck, if everyone's getting a $200 check and would otherwise be subject to $50 of withholding, then for that one employee on leave who received a $200 paycheck, after you withheld and not deposited $50 on each of your, the 3 employees that you still have working and the one on leave, now you've covered the full amount of your credit. The next question that kind of follows onto that example or that line of thinking is, well, what if we have a complete shutdown, so we just don't have enough, if we've got all 4 people on leave and all that we can take for our credit is $50 from each person's paycheck, then that doesn't get us the 200 of credit that we need for each of the 4 employees. And that's where it becomes important to remember that this is a refundable tax credit, which means to the extent that you don't have enough withholding to withhold and not deposit to cover the full amount of a credit that you're entitled to, you can submit a refund to the IRS. Obviously, at that point, cash flow becomes more of a question because you're cutting checks currently and then submitting refund claims and waiting for checks from the IRS. It's an area where the service has already proactively said that they're in the process of drafting forms to create a streamlined process for submitting refund requests. And they also promised that they will issue checks as fast as possible. It's still to be determined, how streamlined the process will be and how fast that they can issue those checks. But they have at least acknowledged that, knowing that a lot of companies are foreseeing a cash crunch right now, that they're going to do the best they can to administer these refundable credits and get cash into taxpayers' hands as soon as they can. So, Kathy, that's I think a couple questions are kind of a mouthful. So I don't know, or Jeff, if you guys want to keep moving, then I can pick back up after you two have taken your next 5.
Great. So I'll take the next 5. Neil, thanks. Question is, what employees are included in the integrated employer test? And our answer is all the employees, full-time, part-time, seasonal. I mean, if they meet the definition of employee under that test, they're all included. Next question, you answered a previous question regarding the pay cap with the cap is the cap. I thought we had to pay their regular pay and only the reimbursement was capped. Is that true? And the answer is no. You don't have to continue to pay full pay for the 10 days of leave under the emergency paid sick leave or under the emergency FMLA. You could if you're the employer of choice and want to do that, but you're only going to get the credit for the amount that's capped. So only have an obligation to pay that amount specified in each requirement under the statute. Don't have to pay the full pay. Next question. On a prior call, it was recommended that employers avoid laying off employees due to COVID-19 prior to the 4/2/20 effective date in order for employees to be able to take advantage of the paid sick and the emergency FMLA expansion. To confirm, is that still the case? Our position is yes, that's still the case. Next question, how does the paid sick leave handle commission employees? Again, our view would be that you have to calculate out what the individual made over the course of the last year to determine what their regular compensation is, including the commission. I don't think you can exclude that. You have to factor that in. Next question, schools were closed on 3/16. Can employees use this paid sick leave for time off back that far? And many of you have asked this question. Our belief is that this act only becomes applicable on 4/2. It's not retroactive. And if people are already off before 4/2, it's not applicable. Again, subject to the Department of Labor determining how that applies. And I think there'll be lots of incentive for the Department of Labor to say that you can go back and make those payments because of all of the stay at home orders from the governors of the various states. The intent was to try to get people money. If this isn't applicable until 4/2 and everybody's already off, they may not be able to get cash under one of the 6 requirements for the emergency paid sick leave. So I guess just stay tuned on that. And the final question before I turn it back to Kathy is, does this law include nonprofit organizations? And again, our understanding is that it does. There's no exemption for nonprofits. Kathy?
All right. So what is the definition of who has been advised to quarantine? By their doctor, by their friend, employer, et cetera. I kind of got to this one earlier, but the quarantine order must be given by either a federal, state, or local order or the advice of a healthcare provider. So employers, friends, enemies, exes, none of them count. What kind of documentation can we request to show proof of these qualifying situations for the paid leave? We don't know that yet because we're still waiting on DOL regulations. I think you're going to get sick of us saying that. But, you know, the fact of the matter is the law is silent as to whether documentation can be required, and if it is required, what that would even look like. You know, I do think it's unlikely that employers will be required or perhaps even allowed to require doctor's notes, since the hospitals are begging us not to go into the ER and to the doctor unless that's absolutely necessary. So I'd be a little surprised to see that. But I guess that's one of those, stay tuned. I expect that will be addressed in some way in the DOL regulations. If the child's school and daycare has closed and the employee is taking care of their child but has the ability to work from home with no time restraints, meaning any time of day, night, do they still qualify for paid sick leave? I think the answer to that is no. So emergency paid sick leave is available when the employee is unable to work or telework due to a need for leave because the child's school or daycare is closed. I interpret this to mean that if an employee is able to work through teleworking, then the right to emergency paid leave would not be triggered. I wouldn't be surprised if you all put some parameters around this. Hopefully they do, but again, stay tuned for that. Next question, are we able to ask employees to work remotely if available when on emergency paid sick leave, if they are not the person that is ill? Yeah, if they're able to telework, then by definition, they're not going to be entitled to emergency paid sick leave. You know, as I've mentioned, that's only available when the employee is unable to work or telework due to a need for leave because the child's school or daycare is closed. And I think that's 5, so I'm going to turn that over to Neil.
Thanks, Kathy. Building off of the question that Jeff answered on whether nonprofits are subject to the leave requirements under the Act, Jeff said they are, and I would add that nonprofits also are can also claim the tax credits under the Act. So one of the questions I've seen is kind of along the general lines of, hey, we're a nonprofit, so my understanding is we're not paying tax, so how do we get the benefit of a tax credit? And although as a nonprofit, you probably are not paying federal income tax, typically you are withholding at least some amounts from employees' paychecks as normal wages. So you qualify for the credit. You can still take it if you're withholding by not depositing that withholding. And then if for any reason, though, you know, your withholding is not enough to cover your credit, you can file for a refund like any other taxpayer. Next question is the credit for employers is how are we allocating costs of group healthcare plans that qualify for credits? And as a reminder on this, the Act says you have to provide paid leave up to the $511, $200 maximums based on the reasons that someone is out. For purposes of the tax credit, whatever you're paying someone under that formula qualifies for the credit, but the rules also say that you can add to your credit an allocation of the cost of providing group health care coverage to your employees by kind of prorating that overall cost out to individual employees. And so one of the questions that we've gotten on that is that part of your $511 a day, $200 a day caps, or is that in addition to those caps? And it is in addition to those caps. So if you have someone that under the formulas, their regular pay would equal or exceed $511 a day, for that person, your credit would equal the $511, plus you would look at the total cost of providing your group health care plan, and then allocate a portion of that cost on a to-be provided formula. It will be some sort of, prorating based on head count, probably factoring in who's part-time and full-time. and adding that amount, whatever it is, to the the $511 or $200 or wherever you come out on the caps before factoring in group health plans. Next question. It appears employers will not be subject to FICA taxes on the leave pay. Will the employee be subject to paying FICA taxes? The first statement in that question is correct. Employers are not required to pay their share of Social Security taxes on a paycheck written to an employee who is out on paid leave. However, the employee's portion is still subject to withholding for Social Security, the same as it would normally be in other employment taxes. That becomes part of the withholding that the employer can not deposit to affect their credit, but from the employee's perspective, they're still getting a check that's net of to the typical withholding. The next question, we've gotten a lot of variations on this, is number one, what if we have people out on for COVID-related reasons prior to the effective date of April 2nd? Can those qualify for the tax credit? The answer to that is no. But from a cash flow perspective, the related question we've gotten on that, and I think there's been some confusion between the effective date and how fast you can stop making payroll deposits. And the answer to that second question is that you can stop making your payroll deposits now in anticipation of needing the cash to cover credits that begin to accrue on April 2nd or later. And the service has basically said that there will be a 30-day non-enforcement period for good faith attempts to comply with the act, meaning that you can stop making your deposits now and then wait and see what cash you actually need after April 2nd. And as long as you're doing everything in good faith, the service is flagging that. I don't think that they're out to hawk it as much as just give people the flexibility to get the cash that they need now. And if you don't get the formula perfect on your first try, there's going to be some flexibility, as long as at the end of the day, people end up getting the credits that they deserve and putting whatever cash they've overwithheld back into payroll deposits when final amounts are known. Jeff, I think that was 5 for me, if you want to pick up.
Okay, yeah, that's great. So I'm going to go off script here a little bit because we keep trying to watch the questions that are coming in. And as you can imagine, there's an unending set of questions we're trying to answer and an unending set of questions that are coming in. But one of the consistent themes in those questions coming in, and it's one that we've been dealing with the last couple of days, if we're a business under any of the state orders for stay at home, that's an essential function, and so we're open, right? We have a letter from our lawyers that says we can continue to operate under the definitions, and we give our employees those letters in case they get pulled over somewhere, and they can provide those to whatever police authority is telling them they need to go back home. But the employee who doesn't have any COVID-19 signs and doesn't have any child care or daycare issues is freaked out and doesn't want to come to work. What are the options? That's the first question we've been getting a lot of. And I think the answer to that is, it's just like any other employment-related issue. You don't have somebody who qualifies under the emergency FMLA or the emergency paid sick leave time, and so you've got a tough choice to make. Hopefully you do that in a professional, reasonable way to say to the employee, we love you, we really need to have you here, we appreciate all the work that you do, we understand that you're concerned, we're doing everything we can in the facility to keep COVID out of the facility, but we're an essential business and we need you here. If you choose not to come in, there are disciplinary consequences that go with that as option A. Option B, you want to be a really great employer and let people take furlough. Our thinking is that's going to become epidemic proportion and you won't be able to run your business, which is going to be a difficult construct to be in. So that's a tough situation, but we think you've got to hold people accountable and get them to come in and do that in a cultural way that makes sense for your business. And then the next part of that was, will those employees who refuse to come in, even though there's work available, be entitled to unemployment? Again, we don't know what guidance each state will provide about that, but our sense under the normal unemployment rules would be that person is not entitled to unemployment benefits because they're choosing to work are choosing not to work when we have work available and they're not constricted by any COVID-19 issues. Again, that's a close call. We'll see what the unemployment agencies do with that. Finally, I'll say there, look, I always talk about 2%ers. The 2%ers are the people who come in and manipulate everything on a daily basis. If you tell them they have to come in if they don't have COVID-19 symptoms, they're going to have COVID-19 symptoms. And then you're going to have to try to figure out how to determine whether they're engaged in fraud or not. And obviously nobody has time or interest in trying to do that right now, but you'll have to work through that as the HR group in the company that you're trying to run as an essential business. All right, so back to some of these questions. Will employees that have already been laid off as a result of temporary business closings still be eligible for the emergency paid sick on 4/2? Again, I think we've answered that a number of times. No, we don't believe so unless Department of Labor guidance changes that. Will there be forms for paid sick leave that employees need to complete? Again, we're waiting for DOL to tell us that. I think it's fair and reasonable for you to create a form if you'd like to do that, just to try to make sure the employees can confirm for you which one of those 6 reasons that are applicable that they're using to take the time off. Do we need to show the employees balance of their paid sick leave hours on their pay stubs as of April 2? Again, the answer to that is no, unless Department of Labor somehow changes that. We have an employee who's been self-quarantined since 3/17. Would she need to take FMLA? Again, this to me sounds like just a regular FMLA issue because the emergency FMLA won't be applicable until 4/2. So if the individual has a serious health condition effective on 3/17 and we didn't get that corrected, we can go back and retroactively apply that FMLA under the normal FMLA serious health condition retroactive regulations. Kathy, I think that's 5. It's your turn.
All right. So next question is, for part-time hours, do we just look at the last 2 weeks to estimate hours? The answer to that is, for part-time employees, they're going to be entitled to the number of hours of leave that they are scheduled to work on average over 2 weeks. So if at the time the leave is taken, the employee has a set schedule, then I would pay based on that schedule. If the employee has a variable schedule, and because of that, you can't determine with certainty what the employee's hours would be, then you would look back at the previous 6 months and find the average hours that they worked. And then you would use that average hours. Going further, if the employee does not have a 6-month history with you, then you should be looking at the number of hours that the employee reasonably expected to be scheduled at the time of hire. Next question, is the 80 hours inclusive of or in addition to the 40 hours under the Michigan Paid Medical Leave Act? The 80 hours is in addition to the 40 hours under the Michigan Paid Medical Leave Act. Next question, we are cutting schedules because of workflow. Does the 6-month look back apply when the employee's schedule has just been cut? Or do we just pay them based on their new scheduled hours? So if the part-time employee's schedule is not flexible, meaning it's not going to vary from week to week, then based on my reading of the Emergency Paid Sick Leave Act, I think you would probably just use the existing schedule. The reason is that the part of the law where it talks about looking back 6 months is related specifically to employees whose schedules vary, such that the employer can't tell with certainty what their schedule would be. I'd say if you want to preserve that employee's old schedule to the extent possible, I'd try and keep their new schedule somewhat variable so you can, go back 6 months at the very least. If the employee called in and says they think they have symptoms, does that make them eligible for paid sick leave? I would say as of April 2nd, if an employee calls in and says they think they have symptoms of COVID-19 and they're seeking a medical diagnosis, then yes, that would make them eligible for emergency paid sick leave. Can employers limit the increments of use of intermittent leave to 4 hours, as an example? That's not clear from either the law or the regulations. I would say that if you're dealing with FMLA extension leave, I think the answer would be yes, because really FMLA Extension Act leave is part of the FMLA. So you would apply the same principles there as you would to a regular FMLA leave. If you're dealing with the Emergency Paid Sick Leave Act, it does speak more in terms of days, but I don't see any reason why you couldn't use it in increments. Again, I hope that is something that the Department of Labor does address very shortly. Let's see, I'm kind of looking at new ones now. Actually, I'm going to look at some new questions that are coming in. In the meantime, I'll turn it over to Neil.
Okay, thanks, Kathy. I saw some follow-up questions in the feed on the example I gave of what if you had an employee who you were paying a check of $200 and you're withholding $50. What is the credit amount? Is the credit for the full $200, and then how do you cover the full $200 if you've only withheld $50 from that individual employee? So the answer in that example is if you've paid $200 to the employee who's on qualified leave, then you are entitled to a credit for the full $200. For that employee in the example, you could, withhold $50 from their check and not deposit that $50 to begin to claim your credit. If, just for simplicity in the example, say that's your only employee, so you've paid $200 and now you've only self-credited back $50, how do you get the remaining $150? That's where the refundable credit comes in. So if you end up in a situation where taking all the withholding and not depositing it that you still are not made whole, that's where you file a refundable credit claim. You're still entitled to the full $200, but you'll have to wait and see what the process is and then go through the process and get that hopefully expedited check from the IRS. The next question, will owners of businesses qualify for the credit? And particularly, what if you're a partner in an entity that's treated as a partnership for tax purposes, or what if you're an owner of an S corporation? The answer is yes. In the partnership scenario, if you're treated as a self-employed owner of a partnership, there's a corresponding credit. So all of the same, calculations and caps and everything we've said about credits in the typical employer-employee situation applies the same if you're self-employed. And if you're an owner in an S corp, typically you're not treated as self-employed, but you are treated as, for payroll purposes, you're treated as an employee of your S corporation. So in that instance, you would also still qualify for the credit. Next question, do credits reimburse for contributions to retirement plans? The answer to that is no. The credit will cover your formula credit, up to the $511 a day, $200 a day caps, plus each employee's eligible share of group health plan coverage, but that's the extent of the credit. There's no additional credit for retirement contributions. And the next question we had was whether you could get a credit if you were paying employees who are essential employees that are still working during the stay-home order. If you're paying them hazard pay, is that hazard pay, does that qualify you for a credit? And the answer to that, again, is no. You get the credits on paid, for paid time off that's paid to employees, and you can affect it the ways we've talked about, but there isn't anywhere, where you get a special or additional credit for paying hazard pay. And Jeff, I'll go back to you.
All right, great. So there are a number of questions that have come up on the live stream because I think people are still wondering whether we're going to let the audio recording be released, and the answer is yes. So the questions that we're repeating, and the answers we're providing will be released as well. Again, our best judgment based on the questions that are being asked. So you'll be able to hear this again if you choose to do that. There are some interesting questions related to how does this apply to temporary/contract employees? And my answer is typically with a temporary at your work, you're a joint employer with a temporary agency. I'm assuming that contract and temporary means the same thing. There are joint employer rules under the Family Medical Leave Act. So if we're talking about the FMLA emergency leave, I think those rules would apply. And essentially, there's a primary employer and a secondary employer. If those don't apply, and the Department of Labor may tell us that, then it would go back to whatever contractual relationship you have with the temporary agency, and whether the commitment is that the temporary makes that payment instead of the primary employer, which is the employer where the employees actually work on site. So stay tuned. I think the DOL probably will give us some guidance on that. If an employee is on sick leave for 2 weeks, does that count towards the 30 calendar days for the new emergency FMLA? Yeah, I think it does. I don't think you have to actually be at work, actual work hours. But again, we may get new guidance on that. Let's see. If we also employ temporary workers, does our company pay for their wages at 2/3 the rate? Going back to the answer I provided previously, again, I think that will depend upon the contractual relationship between you and the temporary agency. Hopefully your contract with the temporary agency says that the temporary agency, would be responsible for that payment. And is it the employee's responsibility to notify the employer about sick leave? The answer is yes. They're supposed to do that as soon as reasonably practicable under both the emergency FMLA and the sick leave provision. And if they don't, what can happen? Well, then you're back to kind of like the FMLA. You can discipline for for the employee not providing the notice, but you can't impact their ability to take the time off. And again, this is a COVID-19 pandemic. I would be very careful as an employer, who I'm disciplining for things like this, unless there's some clear cut fact that shows the person was manipulating the system. All right, couple more here. Did you say an employer cannot request a doctor's note from employees pertaining to COVID-19? Again, I go back to the reasons that people can take leave under the emergency FMLA. I don't need a doctor's note related to the events that I can take emergency FMLA for. Under the Emergency Paid Sick Leave Act, yeah, there are instances where you could do that, but I'm suggesting that probably is not the right thing to do because I'm not sure that any doc's going to provide that during the period of time where we're dealing with a COVID-19 issue. But I think that's an open issue which the Department of Labor will have to give us some guidance on. Kathy, I'll turn it back over to you.
All right, great. Next question. Can you make staff take existing PTO or sick time to cover this paid sick leave, and does this need to come from a different source? If we're sitting here today before the new legislation becomes effective, then sure, you can require them to take PTO or sick time and start drawing down that bank. As of the effective date of the act, if you're covered, then the employee is going to be able to take paid emergency sick leave instead of drawing down their existing PTO or sick time bank. Next question, are we required to notify our employees of this new law? The answer is yes. The DOL is supposed to be creating a posting for you to put up in your workplace. Hopefully that will be done Wednesday. That's when they are supposed to have it done. But I expect that they will have something for us before the date the act becomes effective. Next question, would an employee be eligible for paid sick leave if they simply state that they are having symptoms and that their doctor advised them to stay home, but they are not being tested for COVID? The answer to that is yes. If an employee has symptoms of COVID-19 and their doctor, and they sought treatment by a healthcare provider, then they would be covered by the act. Next question, if shelter in place is issued but employees are still able to work remotely, would they still qualify for emergency paid sick leave? Answer to that is no. if the employees are able to telework, despite the fact that Governor Whitmer's order has closed business for in-person purposes, then they are not going to be covered by the Act because they can still telework. Next question, if as an employer of over 500 employees, can we decide to be more generous and follow these guidelines? Also, if we do, should we all have reasons for an employee to qualify, or can we select pieces that we want to apply? So the first part of that question would be, can we decide to be more generous? Sure, you can certainly decide to be more generous and follow those guidelines, but you're not going to get the tax credit for that. So you can't make yourself become entitled to the tax credit, as far as I understand it. And Neil can correct me if I was wrong on that. To the second part of the question, should we use all the reasons for an employee to qualify or select pieces? I think that's up to you, because you're really not covered by the Act, and you're not going to be getting the credit for the Act. So you can draft your own policies that might be modeled on what smaller employers are providing, but you're certainly not going to be bound by them. I'll turn it over to Neil.
Thanks, Kathy. One of the questions we received is, what is the timing of the refundable credit request? Is it each payroll? I think the answer to that one is a little bit open-ended right now, just because when the Act was first passed, the payroll credits were announced as a quarterly credit, but the Act was passed on Tuesday, and by Friday, based on feedback that had been received from taxpayers, Treasury and the Department of Labor issued a joint announcement where they started to talk about getting cash from the credits to taxpayers faster, and that's where they said that they would create a streamlined refund claim process and issue checks as fast as possible. So I think right now, the most we can say on that is we're looking at an Act that says it would be quarterly, but indications from the Department of Labor and Treasury that they're going to do what they can to make it happen faster. So we'll have to watch the additional guidance to see if they give more clarity on how fast those refund claims can be made, and if you would be able to make an immediate refund claim for each payroll. The next question I have on my list is someone asked, given that the effective date of the Act is April 2nd, what if a payroll that was paid, for example, on April 11th covers March 23rd through April 3rd? Do we only get the tax credit for April 2nd and 3rd? And the answer to that, in terms of what paid time off would qualify for the credit, the answer is yes. Only the paid days off required by the Act that are granted April 2nd and April 3rd would qualify for the credit in that example. But the caveat there is that, like we were saying earlier, if you anticipate that you are going to need cash coming up to pay for time off that would qualify for credits, you can withhold and stop depositing that amount now. So you could still look at that full payroll check for the period March 23rd through April 3rd, and even though only paid days off for April 2nd and April 3rd would qualify for the credit, you could still withhold full normal withholding on that full pay period and not deposit it. And again, you can do that if you reasonably anticipate needing the cash. And I had another follow-up question that kind of dovetails into this, where someone had just asked if we could talk about this process again. And what the guidance says right now is that you can continue to withhold and stop making all deposits to the extent that you reasonably anticipate needing that cash to cover your credits. And the service has said that there will be a 30-day non-enforcement period for people that don't get that calculation right on their first pass. I think if you're doing that, you want to stay in contact with your tax advisors, because I expect likely what they're flagging there is they're saying, we know that we need to give additional guidance on how all of this is going to work. We don't want you to have a cash crunch, so go ahead and stop making deposits now. And then when we issue additional guidance telling you more specifically how this is all going to work, at that point, you'll still have flexibility to true things up to meet the guidance as it comes out without being subject to fees and penalties. Jeff, with that, I'll turn it back to you.
Great, Neil, thank you. So one of the repeated questions that we see in the live stream is this EFMLA 12 weeks in addition to the current 12 weeks? And no, it's not. It's 12 weeks total for all FMLA events. Again, subject to the DOL telling us that we're wrong. That's the way the requirements read currently. Is intermittent leave permitted under the FMLA emergency provision? Our answer is yeah, we believe that it would be, provided you can show that you need to be off intermittently. Another question relates to, under the current FMLA with serious health condition and employer coverage, there have to be 50 employees within a 75-mile radius. How does that apply to the emergency FMLA? And our answer is it doesn't apply at all. It's 499 and less that are applied based on your facility. It doesn't matter how many employees. There are exceptions for under 25 employees for restoration issues, and the Department of Labor still has the right for under 50 to say that certain things are not applicable, but we need to wait for the regs to figure that out. Let's see. Is there a definition of child care provider for the emergency FMLA? Again, the child care provider in the emergency FMLA refers to other regulations about state-sanctioned and federally sanctioned child care, but also specifically says that if an employee pays another on a regular basis money to take care of their child, that can be a daycare center, child care center, so that can be a neighbor, a friend, a relative, a parent. So it's pretty wide open. Let's see. This is a good question. If a parent is caring for a disabled child over 18 years of age, would the EFMLA apply? Again, right now it says 18 or under, and so the 18 or over who with a child who has serious issues related to activities of daily living doesn't appear to be covered, but I suspect Department of Labor may clarify that for us. And then finally, before I turn it back over to Cathy, are both exempt and non-exempt employees covered for the EFMLA and the paid sick? And the answer is yes. And just so the other two, Cathy and Neil, we've got about 10 minutes left in the hour we committed to. So Cathy, it's your turn.
All right. First question, am I correct that the Emergency Paid Sick Leave Act does not have a provision for employees with 30 calendar days with the company? That would be correct. There is no minimum time frame that employees have to work for the company in order to be covered by the EPSLA. Next question. Will this paid sick leave apply to both hourly and salaried employees? Oh, sorry, Jeff just answered that one. So yes, the answer is we expect that it does. If an employee is currently on short-term disability due to a non-related condition, are they only covered for the short-term disability pay after April 2nd, or are they covered under the Act also? I think the answer to that is if an employee is on short-term disability for a non-COVID related condition, and they continue to be on short-term disability for a non-COVID condition, then they would not have any need for leave because of any of the reasons specified in either the Emergency Paid Sick Leave Act or FMLA extension. So no, they would not be covered under the Act. Next question. Our office is currently 100% remote and no one is to enter the office. What is our obligation for this posting? How do we ensure our compliance? The specifics aren't available yet, but my recommendation would be that if you're 100% remote, then you take reasonable precautions to make sure that you've communicated employee rights.
Cathy, are you still there? I think we may have lost Cathy. Neil, are you still there?
I'm still here, Jeff.
Great. So why don't we, if you got a few more, Neil, if you could pick those up.
Yeah, that's fine. I've got one in my queue right now. Someone asked a follow-up question, said they were confused. Is the tax credit for all employees no matter what? And it's not. The credit will cover, it's intended to cover the employer's cost of providing the required sick leave under the Act, or the required FMLA leave under the Act. Where the two, where the employees who are on leave and the employees who are not on leave, where that starts to bleed together, is that you could self-administer your credit by withholding from all of your employees, whether they're on leave or not, and not depositing the withholding, regardless, again, whether that withheld amount relates to an employee who is on leave or who is not on leave. But the calculation of your credit, so you've taken your withholding, you haven't deposited it, but when it comes time to determine, how much credit you actually are entitled to, and, how much of that amount that you haven't deposited you can really keep, that's limited to the amount of pay that you are paying to people who are on qualified leave under the Act. And Jeff, that was the only one I had in my queue right now. If you've got more you want to pick up with.
Yeah, great. So a number of them. What do employers with over 500 employees need to comply with? And the answer is that if you're 500 or over, the Emergency FMLA and the Emergency Paid Sick Leave Act are just not applicable to you. I think the assumption is that larger employers will have other benefit packages that are available to help take care of their employees. That's one reasonable interpretation. The other one is that whoever drafted this wasn't paying attention. But that's where we are now based on the laws. We'll see if Department of Labor tries to manipulate that. It's going to be hard to do, I think, based on the language in the two acts. Next question. Does the emergency paid sick leave and the emergency FMLA, do they coincide with one another? And I think what that question really means is, can I run them concurrently? So for the first 10 days of emergency FMLA, it's unpaid, but employees have the right to use emergency paid sick leave if the event qualifies under FMLA for the first 10 days. So yeah, they can be coordinated together. The employee would have to trigger into the first 10 days under the FMLA based on the child care school closure, which is one of the emergency paid sick leave issues as well. Let's see. Would you consider police corrections officers as emergency responders? Yes, absolutely. For small businesses that are 50 employees, is it 50 employees or 50 individuals or 50 FTEs? Again, no clear guidance from Department of Labor, but when you're running the calculations on the number of bodies you have, I think it's the number of employees, both part and full-time, not FTE equivalents. If an employee has been off since March 17 and can't return until March 31st, is not tested positive for COVID-19, would that person qualify for the Emergency Sick Leave Act, and does it retro back that far? Again, it's not retroactive at all. If they're off on 4/2, but they've been off since March 17, I think there's a strong argument that that act is not applicable to them. On the other hand, if you're an employer that wants to apply it retroactively, you can, just as a good employer, but you're not going to get the tax credit for that. Remember, it's applicable on 4/2/20 going forward. If an employee has a sick spouse, home health care is not able to come into the home because of the risk they present to the spouse's compromised health, and the employee is now the one that has to provide the care, do I qualify for emergency FMLA? My answer would be no, it's not emergency FMLA because it doesn't fit the criteria for it. It's not a closure of a school or a child care center, but I think FMLA, regular FMLA, spouse serious health condition would clearly apply. I'm going to pause a minute. Kathy, are you back on?
Can you hear me?
I can hear you now.
All right, well then I guess I'm back on. I don't know what happened there. So
Yeah,
I'm not
okay.
sure where I left off, but I was answering a question about nonprofits. One of the questions was for nonprofits, are they exempt from this act if they are less than 50 team members? The answer is no. Nonprofits, to our knowledge, are not exempt from the act. I started to answer a question about a remote office. I'm not sure if that was picked up, but the question was, our office is currently 100% remote and no one is to enter the office. What is our obligation for this posting and how do we ensure our compliance? The answer there would be we don't have any guidance from the Department of Labor on the specifics, but I would recommend that we take reasonable efforts to ensure that our employees have notice of their rights under the Act. So, that could be an email to all employees, that could be posting it, on your internal website or external website or things like that. But we'll probably know more about your obligations as the DOL regulations are posted. Another question we got was, scrolling through some now. Are the emergency paid sick leave and emergency FMLA extension expected to run concurrently? I don't think so. I suppose arguably, but really they sort of run together in the sense that the emergency paid sick leave is going to be eligible. You're going to be eligible for that for the first 10 days. Emergency FMLA extension is not available for that first 10 days. So I think they interplay with one another. Neil, are you getting any questions, or should I turn it back over to Jeff?
Yeah, I've got a couple more, Kathy. I think they relate into maybe questions that I'll need some help from you and Jeff on. But someone asked, can public schools qualify for the tax credit? And someone else had a general question on, would government employers qualify for the credit? In order to qualify for the tax credit, you have to be providing leave that is required under the Act. My understanding, Kathy and Jeff, is that government entities, whether they're federal or state or local, are not covered by the Act. So my expectation would be that they're not providing required leave. So in that case, you're not eligible for the credit. But am I correct about government employers there?
So our understanding is that if you are a public employer, you are specifically covered by the Act, regardless of how many employees you have. So even if you have more than 500 employees, you're covered. There's a provision that is referenced in the FMLA. There's another provision in some of the changes in the acts that say we refer back to the employer definition. Kathy, I'll let you comment on that as well. But it seems as though whether you're one employee at a governmental entity or tens of thousands, you're still covered because there's no limitation on the number of employees you can have under the public sector definition of employer.
Yeah, that was my initial impression as well, but all that.
Who knows what DOL will do?
Yeah.
But let me intervene here a second. Again, it's a few minutes after 11. We made a commitment for an hour. We appreciate everybody attending. I will tell you that we feel like we're treading water because we've got another 165 questions that came in, and we probably plowed through more than that. We'll do our best to continue to communicate with the clients that we work with to answer the questions that they have. Appreciate everybody attending. Neil, Kathy, appreciate your ability to answer questions. And remember this, the questions and the answers will be provided on audio hopefully later in the day. So thank you very much. Everybody be safe, and I'm sure we'll chat again.